This is an incredible story of over £8,000 worth of damage to an Audi R8 Supercar without it being involved in a crash. And how, with a little guidance and encouragement from my channel here, it was ultimately able to be resolved. So one of my viewers, Anthony Marcano, who also has his own channel by the way, Sports and Touring, which I'll link in the description below, has an Audi R8 and he had a problem with it. You'll hear his full story in the video linked in the description below, which you'll find over on JM Cars. Both of those are fantastic channels that any car enthusiast must go and subscribe to. So you'll hear Anthony's full story over on that video, but I'm just going to give you the snapshot overview so that I can explain the law, how it applies in this situation, and how ultimately it helped to resolve the situation. I will say at the outset that there is no admission of liability by the would-be defendant in this case, so this is not a finding of fact or a statement of fact that they are liable for this damage, but ultimately the expert involved believes that they caused the damage, but we'll come back to that in a moment. So the thumbnail sketch of the story is as follows. Anthony has a beautiful white Audi R8, but doesn't want to keep it at home all the time, so he decided to pay a garage to store it, to wash it, to cover it, and so on. And he had it there for quite some time without any issues. Only one day, after dropping it off, within an hour and a half, he had a message from the garage to say that there was a warning light on the dashboard. This was a clutch temperature warning light. Now, without going into all the details, I'll leave that to Anthony. Supercars, such as the Audi R8, can get clutch damage if the clutch remains too hot for too long. Usually when it's left in gear, when it shouldn't be in gear, and things like that. So a warning light pops up to say that the clutch is too hot, and if it stays like that, it's going to cause heat damage, as opposed to wear and tear, which is something we'll come back to in a moment. Now, before I move on to the law, there's one thing I do want to mention, which is a little bit of a difficult one, because Anthony went back to the garage, had a quick chat with them, and then decided to take it out for a test drive. He noticed it was juddering, which was the first sign to Anthony that there was something wrong with the clutch. The only alternative would have been to instruct an expert at that stage, which is thousands of pounds, to examine the clutch, take it apart, see what's wrong with it, and then determine that there was indeed a fault with the clutch. But as it happens, Anthony took the vehicle out, which ultimately could have given the garage the perfect opportunity to blame Anthony for the way he was driving the vehicle because he'd taken it out of their care. Now, this is a really difficult one, because what would you do in that situation? Maybe let me know in the comments. Would you have taken it out for a test drive to see whether there's anything wrong with it? Or would you have left it put and get an expert to look at it? Now, I can tell you as guidance that if it were me, I would have wanted someone to come and examine it. Yes, it's going to cost you some money in the short term to come and examine the vehicle, but whilst it's still in the defendant's care, they cannot blame you for having driven it badly and any wear and tear and so on by taking it out. Therefore, if you got somebody to come and inspect it, it would have stopped that at that point, and then they would have said, you need a much more detailed examination and it seems to be damaged. Now, cutting a long story short, Anthony had to instruct an expert to prove that this was the case and that it wasn't wear and tear. And the expert, in their opinion, concluded as follows. To conclude, it was the opinion of the examiner from the findings of this report that in the first instance, the vehicle's clutch system had not failed due to wear and tear, but has failed due to operational procedures carried out whilst in the custody of the defendant. The examiner is of the opinion from the findings of this report that the defendant has not taken reasonable care and skill whilst operating the vehicle, resulting in the overheating of the clutch system, and the failure to comply with the warning light when triggered, resulting in the consequential damage to the clutch and flywheel assembly. The examiner is therefore of the opinion from the findings of this report that the defendant has failed in their duty to look after the claimant's vehicle with reasonable care and skill as per the Consumer Rights Act 2015. In other words, the expert believes that the damage to the clutch and the flywheel was the defendant's fault by the way that they were moving the vehicle, starting the vehicle in and out of gear and so on. But anyway, the short version of the story is Anthony paid to have his car stored at this garage, and it was the expert's view that the way that they'd moved it about in and out of gear had caused damage to the clutch and the flywheel, which ultimately, together with costs, was over £8,000 worth of damage. One other thing worth noting is that Hadfield Audi had also examined the car and their master technicians had looked at it. They were of the view that there was very little wear and tear showing on the visible area of the clutch, and that this judder and the damage was most likely caused by heat damage to the pressure plate and possibly the flywheel friction surfaces due to the hot spots. In other words, it was heat damage and not general wear and tear. And finally, just an overview of the timeline so you can get a sense of it. The incident happened at the end of November 2021. Audi inspected the vehicle in January 2022, and this matter didn't conclude until July 2022, and that's without going to court. Going to court would have probably added maybe a year and a half onto that timeline, all of which potentially the car may not have been in use or able to be used. So moving on to the law, there are three main things I want to talk about in this video that particularly pertain to this situation. Firstly, it's the law that protects you when you're entering a contract for services as a consumer. Secondly, any terms that try to negate liability. And thirdly, relying on expert evidence, because that's a fairly important one that has some cost consequences, which I will come back to later. So first of all, as indicated by the expert report, who will be intimately familiar with this bit of law, any contract for services has an implied term by statute. That means the term is implied into the contract, whether the trader likes it or not. So this is assuming that you're acting as a consumer and you're buying from a business, not from your mate down the local public house. But if you're acting as a consumer and you're buying from a trader, the Consumer Rights Act 2015 implies quite a set of terms into that contract, and you have the right to uphold them. It's not just a term of the contract, you have a right to uphold those terms of the contract. And this is something that many traders seem to try to detract from. If you enter a contract for services, there is a term implied by Section 49 of the Consumer Rights Act, which provides that the service has to be performed with reasonable care and skill. Now, this is mirrored in various other bits of legislation, not just the Consumer Rights Act, but in this particular situation, the Consumer Rights Act Section 49 provides as follows. Every contract to supply a service is to be treated as including a term that the trader must perform the service with reasonable care and skill. And this is a relatively simple principle of law. If you are paying somebody to perform a service, they should perform that service with reasonable care and skill. They should do a good job. And if they don't do a good job, you have the right under the Consumer Rights Act to enforce that term, and therefore it would be a breach of contract. If there's a breach of contract, i.e. they haven't performed it with reasonable care and skill, then you can enforce your right to uphold that term, and therefore it's a breach of contract, and you can claim damages that arise from that breach of contract. And the trader will be liable to pay you those damages from anything that arises from that breach. That's the simple principle of law upon which this works. So applying that principle to this situation, Anthony had paid the garage to look after his car. The expert report shows that they hadn't done so with reasonable care and skill. We'll come back to the expert report in a moment. But because they hadn't done so, it's a breach of contract, and Anthony would most likely have been successful in a claim for damages had the matter ended up in court. Now, as I said, and just a reminder, this did not end up in court. The garage did not admit liability, even though they paid for the damages. Now, before we get on to the expert and their report, I want to talk about the terms that were purportedly signed by Anthony with this garage. Because in fact, two sets of terms surfaced. The one that Anthony believed he signed, and then the one that the garage believed was in force, both of which pertaining to liability. So the one that Anthony believed he signed reads as follows. The customer relieves the named individuals of the garage of all personal liability for loss and damage to vehicles or contents, however caused. All customers are therefore respectfully notified that we do not accept personal responsibility for loss or misdelivery of or damage to any vehicle accessories or other goods while in our hands for any purpose arising from any cause. This condition extends to customers' vehicles while being driven or moved by members of our team or while standing. However, we do have a fully comprehensive insurance policy. So this clause names two individuals and seeks to relieve them of all personal liability for any damage howsoever caused within this contract. I'll come back to that in a moment, because the second version of these terms, given by the garage, reads as follows. Regarding our terms of service as signed by you on the 2nd of October, which by the way Anthony doesn't accept because it doesn't match the version that he says he signed, reads, all customers are therefore respectfully notified that we do not accept responsibility for loss or misdelivery of or damage to any vehicle, accessories or other goods while in our hands for any purpose arising from any cause. This condition extends to customers' vehicles while being driven or moved by members of our team or while standing. I trust this now closes the matter. So this version of the terms removes the two names and removes the term of personal responsibility, which again I'll come back to in a moment, but this version doesn't match the version that Anthony says he signed. Now, the first point I'll note about this is that if the terms change, unless Anthony has agreed to those changes, they cannot just unilaterally change the terms that Anthony's agreed to. Anthony signed the first set. However, that aside, as the lawyer, if I were instructed on this case, I would take issue with that whole clause in its entirety in any event, because there is a principle in law and certainly in the Consumer Rights Act that if a term is unfair, then that term is unenforceable. So if a company were to say, if XYZ event happens, you need to pay us £50,000, that's clearly an unfair term because it's a significant imbalance between the parties, therefore it's unenforceable. So if they slipped that term into the contract and then tried to sue you for £50,000, that's going nowhere because it's unfair and therefore it's unenforceable. If you want to read more about this, you need to look to Schedule 2 of the Consumer Rights Act, Part 1, which has a list of terms conveniently, which you can read and compare them with terms of contracts that you might have entered into. This provides a list of terms which are likely to be unfair. And remember, if they are unfair, they are unenforceable. And you don't have to go very far to find one that's relevant to this particular situation, because if we look at the second term, it reads as follows. A term which has the object or effect of inappropriately excluding or limiting the legal rights of the consumer in relation to the trader or another party, in the event of total or partial non-performance or inadequate performance by the trader of any of the contractual obligations, including the option of offsetting a debt owed to the trader against any claim which the consumer may have against the trader. Now remember that as a term implied into the contract, the garage will have had to perform this with reasonable care and skill. This is a term implied into the contract. It is part of the contract, whether they like it or not. I've got a bit of a story I'll come back to in a moment. I've got a lot of things to come back to, so forgive me if I forget any of them. But this term is implied into the contract. So any term that has the object or effect of inappropriately excluding or limiting the legal rights of the consumer in relation to that term implied into the contract, in relation to the inadequate performance by the trader of any of the contractual obligations, is most likely going to be an unfair term and thus unenforceable. So for what it's worth, and in my view, that whole paragraph that says, if your car gets damaged, it's not our fault, we're not going to compensate you for it, is pretty much meaningless. It's unfair, therefore it's unenforceable, and a court is not going to look kindly on a term like that. In fact, trading standards might not look kindly on a statement like that, because it's a term that purports to limit and restrict your legal rights, and they are rights because they're in the Consumer Rights Act, your legal rights in relation to a contract that you've entered into. So if there is a term like this that is seeking or purporting to limit or restrict or curtail your rights, it is an illegal term, and trading standards don't take kindly to terms like that. It's a bit like when shops say no refunds. That's not strictly true, because if a product doesn't conform to the contract because it's not of satisfactory quality and so on, they cannot say no refunds because they must give you a refund in certain conditions. And this is one of those. And this could well be one of those situations where the term is seeking to limit your legal rights, which ultimately is ineffective. So now I said I would come to talk about the expert. Now, just to explain this a little bit, when you get to court, the court is not necessarily an expert in all things. It relies upon the evidence given by other people, and for expert matters, it relies on experts in that field. So for argument's sake, in the martial arts field, I would be an expert because I've done martial arts for over 30 years. If the court wanted an expert view on how a particular technique was used, that's not proper martial arts, by the way, then the court might come to me because I'd be an expert in that. If the court wants to know about clutches, they will go to a master technician, some kind of mechanical engineer expert with a whole string of qualifications to say that in their expert view, this is what or what did not cause damage to this particular clutch, flywheel, whatever it might be. In this case, as you'll remember, the expert concluded that the damage to the clutch and the flywheel occurred during the defendant's possession, the defendant garage possession, or the prospective defendant garage possession, whilst they were moving it about. So in the expert's report, they concluded that it was in their care and they did something wrong. It was whatever they did caused the damage to the clutch. Now, the court is obviously going to need to rely on that sort of evidence, expert evidence. The problem we have here is under the civil procedure rules, the expert report can only be relied upon in court with the court's permission, which does throw up a bit of a difficulty because if you've already expended costs on an expert report, there is no guarantee that the court is going to give you permission to rely on that expert report, and thus you may not guarantee that you'll get those costs back. What might happen is you've spent a few £1,000s on an expert report, and that bolsters your case, and so the other side will be pressured into settling it with you because the expert report says that they are responsible, if that's the case. However, you cannot necessarily rely on it because you won't know that until you get to court and you get the court's permission to rely on that expert report. The court may say you have to instruct another expert. One reason for that might be if the other side has arguments that the expert is impartial, they don't trust your expert, or they don't trust that the expert is impartial and independent, because experts have to sign an oath and a declaration that their evidence is independent, it's objective, they're not related to you, and they've not been biased in any way. And if that's the case, the court might just give you permission to seek another expert report, which you'll then have to pay for. The court may sometimes order what they call a single joint expert, which is one expert that gives evidence for both parties, if that can be agreed, or on some occasions the court might give permission for two experts, one for either side. If they don't agree, then they have a discussion, and if they still don't agree, then they have another expert, and then they have to rely on what the third expert says their conclusion should be. However, that said, I make no criticism of Anthony in this case, or the solicitor. I think the solicitor did a great job by all accounts, by what I've heard, because Anthony got this expert report, which was fairly conclusive and said that's what we think happened, and that ultimately pushed the other side into agreeing to pay the costs. It didn't go so far as to pushing them to admit liability. Again, I make that clear because there is a distinction between admitting liability and making a commercial decision not to fight a claim and just pay out for the damage. Now, by all accounts, it would probably be cheaper to pay for the damage than it would to defend a claim, because defending a claim like this in court would probably easily run £10,000, £15,000 or £20,000 to properly defend a claim like this. And with an expert report against you, one defendant company or prospective defendant company might take the commercial view, particularly probably because it was an insurer involved. They might have taken the view that, look, it's commercially more sensible just to pay out for the damage because they mitigate the risk, or they eliminate the risk by paying the damages. They eliminate the litigation risk of going to court and then losing their own fees and losing Anthony's fees if Anthony paid to go to court, because again, it's going to be tens of thousands of pounds to ultimately run this to trial. But ultimately, me taking an aerial view on this case, having had sight of the expert report and having had sight of some of the correspondence and some of the terms, and obviously hearing Anthony's story, in my view, I would be saying that this is a fairly strong case that the garage caused the damage to the vehicle. Now, that's no determination of fact because that can only be made by a court. But if I were fighting this, if I were advising on a case like this, I would say this was a relatively strong case. So if you're in a position where you've paid for a service, whether it's a car, storage, or whether it's putting up a fence outside, if you feel that the job hasn't been done with reasonable care and skill, i.e., to use the same analogy, if you put a fence up and the fence gets blown around and blown down, then the fence hasn't been put up with reasonable care and skill because it's not a very good fence. The analogy is exactly the same. The same law applies. It's implied into the contract whether the company likes it or not. Now, I did say I would also come back to a story about implied terms into a contract. Now, when we're writing a letter of claim, which Anthony did correctly with a solicitor, which I'll explain again in a moment, when we're writing a letter of claim, we very often just summarise the position. At least as a barrister, I summarise the position because the lawyer on the other side should know which bit of law that I'm referring to. Now, there are several bits of law that implies the same terms, broadly the same terms or the same effective terms into a contract. So, for example, we've got bits of legislation that apply to businesses and bits of legislation that apply to consumers, and we even have a separate bit of legislation that applies specifically to hire purchase agreements. So I'd recently sent off a letter to say there was a term implied into the contract that the thing that was hired was of satisfactory quality and fit for purpose. The solicitor wrote back to say that I'd misunderstood the law, that the Consumer Rights Act didn't apply. But I'd never said the Consumer Rights Act applied. I'd never in fact said that my client was a consumer. My client wasn't a consumer. My client was a business. I said that the term was implied into the contract because it is. It is implied into the contract, just not by the Consumer Rights Act. So one of the hugely frustrating things that we have as lawyers, at least some of us have as lawyers, is when the opposing party, usually through a solicitor, not always, but usually through a solicitor, will write back and throw up arguments and say, we don't agree to this and we don't agree to that, and therefore we're going to fight you on it. which ultimately means for the client that it's going to be a year and a half of legal bills back and forth, all the while the vehicle might be sat on the drive if it's a vehicle, or the work is just left standing, but all the while the client will have a duty to mitigate their losses, which means if it's unfinished work that's going to cause damage, they need to pay for the work to be finished so that it doesn't cause more damage. All the while they're trying to sue for the inadequate work that was done in the first place. I see lots of cases like this with inadequate building work, vehicles that have just not been up to standard. In fact, in one case, which I'll go into a great more detail for in another video, because otherwise this will be far too long, one of the case with a brand new vehicle to the value of around about £90,000, within a couple of weeks of release and collection of that brand new vehicle, the manufacturer received a recall notice by the European Commission to say these vehicles are not safe because they are catching fire. The vehicle manufacturer still tried to defend the refund of this vehicle, even though it was within the first 30 days, which, by the way, is a 30-day right to reject for the rights under the Consumer Rights Act, including satisfactory quality, fitness for purpose, and all the rest of it. The consumer has a right to reject this vehicle within 30 days if it doesn't meet the terms of the contract. Now, in my view, it's a fairly slam dunk case that if the manufacturer has a recall notice for the vehicle because it's catching fire, that is sufficient evidence that this is not of satisfactory quality. Nonetheless, they refused to refund my client, and we spent around 8 months arguing over it. I did what I always do if I'm about to issue proceedings on behalf of a client. I rang them up and said, this is a courtesy call. I'm about to issue proceedings right now. Because I'm authorised to conduct litigation, by the way. Most barristers don't. It's normally solicitors that conduct litigation, but I'm authorised to conduct litigation, which includes the filing of a claim. So I was about to file a claim, and I made this courtesy call to say, I am issuing proceedings today if we don't get a settlement. Lo and behold, my client got a replacement vehicle to equivalent value with 1 or 2 years of free servicing for the inconvenience, and so on and so forth. There's a lot more about that in all of my other consumer law videos, but that just goes to show how frustrating it can be when you're fighting a company like this. So I have to commend Anthony for all the steps that he took. I'm glad that the 1 or 2 steps that could have caused significant problems didn't, and I think relying on the expert report was a very good move because that supported and ultimately solidified the position that the expert believed the defendant was responsible, and therefore it allowed the solicitor to go in strong and say, we have this expert report, this is what we think is going to happen, we will sue you if you don't pay for the damages. So the prospective defendant garage, in Anthony's case, made the commercial decision to pay for the damages instead of fighting the claim that would have been issued in court. Now, just to round off this discussion on the law, it's very difficult for consumers, in my view, to fight these things because there is a limit of £10,000 before costs come into play. Now, what I mean by that is a small claim is a claim not more than £10,000 and is not for anything other than a liquidated sum of money, i.e. you're not asking to restrain somebody from doing something, you're asking for an amount of money. If it is not more than £10,000, then you ordinarily cannot claim your legal costs. But conversely, the other side cannot claim for their legal costs either. But in cases where the costs are likely to be more than £10,000, like my client with the £90,000 vehicle, immediately the cost implications will engage, meaning my client is at risk of costs, as is the garage. But in most respects, a consumer is usually likely to be on the back foot because the companies almost always have deeper pockets than my consumer clients. Not always, because some of my clients are multimillionaires and they can and do take these big companies to court. But ultimately, the law is the same, whether it's a small claim worth not more than £10,000 or whether it's worth several £100,000, the rules are the same and the law is the same. So I hope that is of some use to you. I hope the overview of the law is somewhat interesting when you go and watch Anthony's story in the description below. Please do remember to like this video and subscribe if you found it useful. Check out some of my other videos where I talk about similar issues. And as always, thank you for watching.